November 10th planning board meeting. I'd like to also welcome Gordon Gooding, our new councilman as of today. Thank you for joining us. As we always do, review last month's meeting minutes. We paid 2 bills. We acted on 2 resolutions. SH29 West Neck LLC lot line adjustment extension and the Chequet Avenue LLC secret lead agency determination. We had a public hearing for the DeFal and Shearer lot line adjustment, 11 and 13 East Brainerd Parkway. Does anyone have any questions about this or discuss changes?
No, it's good.
So I make a motion to accept the November 12th planning board meetings minutes.
I'll second that.
All in favor?
Aye.
We have a handful of bills. I'm going to switch the order around a little bit. First, it's for the Rayner Group for services rendered in November. It totaled $2,227.50, and it all dealt with the Fowler major subdivision. An assistance we definitely need, so I make a motion to accept the Rayner Group's invoice for $2,227.50.
Second.
All in favor?
Aye.
And Marcus?
We have a few other bills from our attorneys. First one, which is a small one, is from the Perillo Hill Law Firm. And it's for reviewing a decision on the order of the petitioner's motion to re-argue and renew. And the fee for that was $67.50. I'd say pay it right away before we get.
Yeah, I'll second that.
So I'll make a motion to accept the Perillo and Hill invoice for $67.50.
I'll second.
Second?
I'll second.
I abstain.
You abstain, right?
Right, got to do the vote.
So then,
All in favor?
all in favor? Aye. Now we have another big bill from the Essex Hefner, but it's for 3 months. It's for September, October, November. So it's a quarter of a year. And I'm going to go through this month by month. So for September, it's $2,700. And it's stuff like corresponding with the planning board chair and the town attorney, corresponding with the town engineer, stuff like that. Everybody take a look at that. So I'd like to make a motion to accept the EHA invoice for September in the amount of $2,700. Do I have a second?
I'll second for you.
All in favor?
Aye.
So the next invoice is from EHA also. It's for the month of October. And it's, after the discount, it's $4,753.12. It's for the draft of 3 Borough Hall Lane. It's for the draft resolutions for West Neck Creek Cottages, the resolution for Tesoro, correspondence on seeker. There's like 18 items in here. And again, the amount is $4,753.12. So I'd like to make a motion to accept the EHA invoice of October in the amount of $4,753.12. Second, okay. All in favor?
Aye.
Okay, one more to go. And lastly, for EHA, we have the month of November, and it was reviewing and updating applicant response to 7 Chequet, begin drafting Dufault Scherer resolution. Amount is $1,800. Everybody look at that. So I would like to make a motion to accept the Essex Hefner invoice for the month of November in the amount of $1,700.
1,800?
$1,800, I'm sorry.
I'll second that.
Yeah, second, all in favor?
Aye.
Okay.
We have four items to review and act upon. The first is the DeFoe and Shearer lot line adjustment, which we had a public hearing for last month. This would be resolution number 37 of 2024. It was a simple swapping of land, makes both properties, one property a little less non-conforming than the other. I think it was a total of 930 square feet being transferred from one lot to the other. And we didn't have any problems with it. This will require them to submit deeds for our review and then filing with the county and then submitting a plat, which I will sign if everything's in order, and then submitting that with the county. And they will have currently until June 10th, 2025 to do so. I think it's very straightforward, so I'm going to make a motion to accept resolution number 37 of 2024 for the lot line, approving the lot line adjustment for Christine DeFoe and Kathleen DeFoe and Alex Shearer. Do I have a second?
I'll second that.
All in favor?
Aye.
The next one is for the extension of the lot line approval for Elliott and Bausman. This would be resolution number 38. And it will, since we short cycled last month, we're actually, this is going to be two extensions combined into one, which will take the applicant till February 11th, 2025 to submit the recorded plats. We did receive the health department approval, and I just signed the plat, so I don't think they'll need this amount of time, but it's just a matter of that we have to go through this. So I make a motion to accept resolution number 38 for the Elliott and Bausman lot line adjustment. Do I have a second?
Second.
All in favor?
Aye.
Next one would be resolution number 39 for approval of the sketch plan for the major major subdivision. Reviewed the plan over the last month, and the applicant made, I think we were okay. Actually, we've been looking at this one for some time. And the applicant is putting a 50-foot buffer along Nostrand Parkway. And we've asked that part of this condition would be an additional 50 feet for any structures. So in effect, having a 100-foot buffer.
Sorry to interrupt, but I know I received a call today from Carl Benacasa,
Okay,
just asking about that 50-foot, the additional 50-foot buffer. I don't know if you might have a comment before you guys adopt it.
sure. Carl, do you have a comment on our proposed resolution or?
Good evening. Yes, I spoke with Liz, as she mentioned, and I actually spoke with Joe as well today. We understand the board would like to to add 50 feet to make that a 100-foot buffer. I spoke with my clients that will disrupt some of their plans development of the property. In his memo at the last meeting, Joe had mentioned putting a 10-foot setback from the buffer as an addition, not an expansion of the buffer by 2 times. My clients are willing to certainly work with the board and appreciate the board's concern. What they were hoping the board would consider would be an additional 10 feet, and then on top of that, a 10-foot buffer. So it would be, a 10-foot setback from the right of way. So it would be a total of 60-foot buffer, and then a 10-foot setback from that. So no structure would be within 70 feet of the road. That's an additional 40% beyond what zoning calls for. I don't know exactly the nexus between this enhanced requirement. The only consideration the only comment we saw with respect to the buffer in the memo was that it needed to be 32 square feet larger to accommodate the park requirement. Obviously, another 10 feet across the span of the property would do that. And just respectfully, we would ask the board to reconsider the additional 50 feet and compromise on 10 feet with, again, that 10-foot setback. So really, again, we're talking about 70 feet for any structures from the road.
So you were with us for our last meeting where I think I brought up that I felt that the buffer should act as the road in essence as a setback, and that the AA zone of 50 feet should be held back from the buffer. In speaking, I think I can speak for the rest of the planning board. There have been precedents in subdivisions off of Cobbett's Lane where the subdivider was held to a 100-foot scenic vista setback. This is also a very special part of the island with a beautiful tree-covered pathway, road. And I think having the additional buffer of trees in their current state is something that I think the other.
It also aligns with the current comprehensive plan values in terms of the scenic view from the road, especially that road, so.
So I know I feel strongly about maintaining the 50-foot front yard setback from the proposed 50-foot parkland. I would.
Yeah, I mean, I agree. I mean, you still own that land at 50 feet, but you just have to, covenant it so it won't be disturbed. Just keep it natural forever. Just like when you go down Cobbett's Lane, if you look into the subdivisions over there, they can't build for the first 100 feet, So if you go down there, it feels like there's really no houses,
I'm going to clarify that. We're just talking about a 50-foot building setback from the parkland.
Oh, okay.
I don't think we were talking about saying that they had to maintain woods for 50 feet in.
Well, that's what I heard.
I don't.
Not for an additional 50, no. Right.
It was explained to me as a additional buffer. So maintaining the woods. Are you saying that it's just 50-foot setback for principal structures?
That's how I was envisioning it, but
I was thinking it's natural because they got a huge area to build, and it's a win for the person walking by who still sees nature, and it's a win for the eventual homeowner who will have more privacy from the road.
they're big lots.
They're huge lots, yeah.
I'd like to stick with our original proposal. Keep it as is. I don't know how to. Matt?
Matt, what are your thoughts?
Yeah, I mean, I like our original proposal. If it's going to be 70 feet of natural as opposed to 50 and then a lawn, those are two very different things.
Well, if it's just a 50-foot building
You were saying
setback,
just 50
so it would
feet,
be 50 foot of woods and then
they could put a
front
lawn
in
or whatever.
Right, so they still have.
So I think we need to clarify that, whether it's 100 feet of
So
woods or
we're not ready to go
50.
ahead with this resolution? Do you want to then table this and discuss?
Yeah, I think we should, because I think there's a little confusion.
Like we have,
Expect-
it seems like we have slightly different views, so. Seems worthy of a conversation if that's possible.
And I think a 70,
Michael, I see here, but this is not a public hearing on this. We will be having a public hearing on this. Okay?
guess the fact.
You can't talk.
We're not opening this to public discussion.
You're not opening it to a public discussion, but question.
Not right now.
No, not right now.
I understand what you just said.
Okay?
Will you be opening it to a public discussion in the future
We will have a public hearing on this application,
as a sketch plot?
not as a sketch plan. We do not do sketch plan public hearings. That will be the next stage that they go through when they actually submit their preliminary plan. This is just sketch.
And there's no opportunity for public hearing on
No,
sketch?
no. So, let's table this for discussion, further discussion. Is that acceptable, Carl?
Yeah, if obviously if the board's needs more time to consider their position, we'd encourage that. I'll submit a written letter to the board in the interim, just outlining our position, so that can be part of the consideration.
Sounds wonderful. Thank you.
That would be helpful.
Thank you very much. Have a great evening.
Thanks.
Hello, Ben. How are you? I see we have 3 town councilmen here tonight. I'm just, we have a quorum of the town board.
You have to call a
Just
meeting.
want to make a notice of that.
Well, as long as Gordon doesn't say it, then we're good.
That's not how I understand it, but okay.
Beth?
Yeah, no, that's not how it works.
On town council. Their own council.
So the next resolution would be the extension for the approval of the lot line adjustment for the Radigan property. This would be resolution number 40.
So it should be 39, changing the numbers because we didn't end up.
Should we just skip 39 or do you want to go to 39?
No, we should change numbers.
So this will be resolution 39. 2024. This will give them an extension until February 11th, 2025. We have the deeds. I think, Beth, you've read through them.
I have not had a chance to read, I have them, but I have not had a chance to read.
So we'll be reading through those and then sending them back if they're appropriate to file. So I make a motion to accept resolution number 39, the extension of approval for lot line adjustment for Rick Radigan. Do I have a second?
Second.
All in favor? Okay, so the next part of the business meeting is a public hearing for Cheekwood Avenue LLC, it's wetlands application at 7 Cheekwood Avenue. I'm the architect for the homeowner, so I must recuse myself.
Christina, can you read a note?
Shelter Island Town Planning Board will hold a public hearing pursuant to section 127-4E on the code of Shelter Island, the town of Shelter Island, at the 7 p.m. prevailing time, December 10th, 2024, at Shelter Island Town Hall, Shelter Island, New York, at which time all interested parties shall be heard regarding an application for wetlands permit by Cheekwood Avenue LLC. The property which is subject of the application is located at 7 Cheekwood Avenue, Shelter Island, New York, Suffolk County Tax Map 700-5-1-11. The applicants are requesting a wetlands permit to allow 426 square feet of a new 1373 square feet accessory sleeping structure to extend into the adjacent regulated area on a bulkheaded property, secret class type 1. The correspondence has been received from E.W. Grosser on October 1st regarding comments to the AEF. October 10, Howard Johnson submitted objection to planning board declaring the agency status for secret review. On October 10, Shelter Island Heights Property Owners Corporation objected to the designation of the planning board as a lead agency and the secret. On October 17, Sherman Engineering submitted narrative revisions. On October 30, Sherman Engineering submitted response to Hyde property owner declaration letter. November 11, Pam Demarest submitted objection to the Cheekwood Avenue application amendment. November 12, Heights noted strong objection regarding the planning board desire to be named lead agency in the secret review. November 12th, Stephen Kiley, town attorney, requested Shelter Island Town Board to be included as an interested party in secret review. November 13th, Sherman Engineering submitted a letter in support of the planning board review in response of the Heights letter.
Okay, thank you. Is anyone from the CAC in the audience, in the Zoom audience? Mr. Johansson? So apparently, they didn't have a quorum at their November meeting, and at their December meeting, they didn't even bring it up. So we have no CAC report. Traditionally, that was the time we do the CAC report. Should I read from last year's report? Because it's a different thing, you know, so.
Well, I mean, it's the I don't, last report we had.
It's from
It's the last
February,
report you have.
from May 8th of
I think
2023.
the code gives them 45 days
Right,
to actually respond. However, I also don't anticipate the record closing tonight. I anticipate it not closing until, at least until until January. So they still have time to submit. I don't know when the next CAC meeting is.
Yeah, I believe it's in January, a week prior to the planning board.
So they would still have, technically still have time to submit prior to the next board meeting. The record would still be open. I anticipate that.
And that option.
all
That seems, that's certainly more reasonable. And then if
Yeah.
they don't do anything, then we can do it next time.
Yeah, I mean, by that
If we
point,
choose to.
I think it's been a few months.
Matt Sherman, you want to walk us through this?
Hey, good evening, Matt Sherman. I'm here on behalf of the property owner and applicant, Cheekwood Avenue LLC. I've got a very quick presentation to show you all tonight. Again, this is a continuation of the hearing that we've already had and the wetlands permit that was already approved. Just to kind of give you, obviously we all know this already, but just to recap the process and how it's occurred to this point. We started this with a hearing in June of 2023. Had several hearings after that where we brought up information. Concerned parties in the audience had brought up questions and information. The board had asked questions, and a lot of that, all that stuff had been discussed, had been reviewed, had been digested, and it ultimately resulted in the planning board issuing a wetlands permit for this project on, the original resolution was October 10th, 2023. After we got the permit from the wetlands, we went to the building department with the set of plans that are reduced from what was approved as a wetlands permit. And the building department issued a building permit for those plans on December 13th of 2023. And shortly after that, the neighbors had filed an Article 78 challenging the secret determination and the process that the planning board had gone through, saying the planning board should not have designated this as a type 2 action, should have been a type 1 action. The court agreed with them, and that's what brings us back here tonight. Over the course of this past year, we did the full environmental assessment. We did the narrative. We submitted that information several times back and forth with the planning board and the planning board's consultant. The lead agency designation, as was mentioned in the hearing, notice that the designation was, that occurred last month. So the planning board is lead agency. I don't know if you've gotten a report from your secret consultant as to what their recommendations are on the final disposition of that, whether it's a negative declaration or what the result was there. But if I could share my screen, I will very, very brief presentation showing the reduction in the building that we're talking about. There's a little bit of a lag here, okay, bear with us. Okay, as part of the FEAF, and as a request from the town's consultant, PW Grosser, they asked that we put together a couple of renderings to show in a real-world aspect what this accessory building would look like, specifically compared to the closest neighboring structure. So that's what this first rendering is. This is a architectural rendering of the proposed building, and this is the neighboring property. So just to kind of, you can get a feel, it's a little bit further back from the wetlands, from the seawall, significantly smaller of a building, as well it should be. It's an accessory sleeping structure as opposed to a three-story single-family dwelling. The site plan, that remains the same as what was already approved. The footprint is the same, the location on the property is the same, the distance from the wetlands is the same. What has changed is we've removed part of the previous approval. That previous approval had a section of building over top of this covered porch. So that's been taken away. We've reduced the size of the building. What's also changed is the waterfront stairs were reduced in size a little bit and slid over to the side so that they're not as much of an intrusion in the regulated area. The regrading remains the same, stormwater control remains the same, everything else remains the same. So we've got those two reductions. The regrading, this was part of the original application. We've got a small area underneath the building that gets raised between 0 to 12 inches. That's that bright green here. And then those two little pools of darker green, those are just right by the stairs. Those get raised between 1 foot and 18 inches from existing grade. These are the two areas that Teresa Mason, the town's environmental consultant, the only real comments she had on this project was that she didn't like that regrading. She had a few other things. She wanted a covenant placed on the deed so that the vegetative buffer would remain, categorizing of the types of vegetation that are within the vegetative buffer, things along those lines. But as far as an actual change to the project, it was that regrading there in that area. That was the concern. So these are the site plan, or excuse me, the building plans that were approved by the building department in that December 13th building permit. So we've got on the first floor, we've got a wet bar, a sink, a refrigerator. You've got a sitting room, which is just over half of that first floor. Entry and entry stair, and then a half bath on the first floor. Stair goes up to the second floor. What we did was we removed an office, and that allowed us to shrink that second floor so that we no longer come out over top of this covered porch. So by removing the office, we're able to remove a significant portion of that second floor, pulling it back so that it's a reduction in what was originally approved. On the second floor, we still have the two full bathrooms, and we have the laundry room in one of the bathrooms. There's not a laundry room, but laundry closet in one of the bathrooms. So here it is from a elevation. The top elevation is looking at it from the roadside. The bottom elevation is looking at it from in the interior of the property. So again, this area here is what was removed from the building. These are from the original application, just to kind of refresh you of what the vegetative buffer looks like there now. We've got that small seawall. This seawall was actually raised up after Hurricane Sandy. The only time this property is ever flooded is from Hurricane Sandy, and afterward, the seawall was raised to help prevent that from happening in the future. So along the entire length of the property is that concrete seawall. On the right-hand side, obviously, is the beach. You've got the couple of rack lines. You're gonna have mean high water. It's in this area between these rack lines and this general area. You've got your vegetative buffer on the landward side of that bulkhead. This is from the neighbor's property, looking down into the property in question. Looking down Willow Path, looking eastward toward the, going around the corner toward the yacht club. So you've got Willow Path is that mowing path that's right in front of you. To the left-hand side is the vegetative buffer. To the right-hand side is the pool fence. The lawn and the pool is to the right of this. And that's just the same thing looking in the other direction. So you've got a very, very well-established, well-maintained, and substantial non-turf buffer in this area. So this is the area that we're talking about where the building's gonna go. It's back up in this area here where these trees are. So it's manicured lawn at this point. That lawn will go away in that area where the building will be, and we'll have leaders leading into dry wells. Stormwater will be collected. We're proposing to collect for a 2-inch rainfall. That was confirmed to be correct by the town's environmental consultant. So as far as the stormwater control is concerned, we're in pretty good shape. This is another view of that same area. And that's what I've got. So the biggest things, the takeaways from this thing, let me stop my share. The takeaways from this, and whatever questions the board has for me, I'd be more than happy to answer them, are that the existing plan that was approved by the planning board originally had on the first floor, we had an overall coverage in the adjacent regulated area of 434.7 square feet. That's being reduced to 426.5 square feet. It's not a lot, we're only bringing it down by about 8 square feet, but it is coming down some. So the change in this project is not an addition, it's not anything new, it's the exact opposite. It's the reduction, it's the taking away. I've got, if the board has any other questions for me, I can answer any questions directly from you. Otherwise, I can step aside, let other people speak, and answer any questions that you've got from what other people have. Just let me know, I'll be more than happy to address them.
Good, thank you.
Matt, question about I just have the notes from Mason, the consultant. So she was asking about one second, I gotta find it, I just had it. In restoring the native vegetation, and you had commented that on the one side by that walking path, there actually, it looks like there is some native vegetation, but then there's that walking path.
Right, yeah.
So you had said that would not, you would not be able to do anything over there because of that reason. But how about on the other sides? I forget what you said. You're just gonna leave it as it is?
Yeah, the plan is to leave it as turf grass between the swimming pool and the fence.
Okay.
Yeah, leave that as turf grass. Yeah, where Willow Path is, obviously we can't infringe on that. That's a Heights walking path that leads from the ferry office all the way down around the point over to the yacht club. Yeah.
You could also mention that the applicant would be open to having a covenant on the deed about somehow maintaining this buffer.
Yeah. I mean, the town board is discussing that now, I believe.
Yeah.
And whatever they come up with as their final resolution to how they don't want people to do that, yeah, I don't see that being a problem.
So what are those two numbers again, just so you went a little faster? So it's 430.7 down to 426.5?
Yeah, that's the amount of building coverage within the adjacent regulated area. Not within the vegetative buffer, that first 75 feet to 75 to 100 feet.
What was the overall reduction?
The overall reduction, the original plan, we were at 2,287 square feet.
Yep.
The proposed plan, we're at 1,864 square feet. So we come down by what, 100 and change? Yeah.
Basically that room.
What's that?
Basically that room was like mostly.
That room was removed, yeah. The idea originally was that the The family of the property owner was gonna come out, spend a fair amount of time in the summer. And, we're all working, we've got Zoom meetings, we've got, things like that, that we wanna have if you can, have a dedicated area where you can work. That ended up, if that's a bridge too far, fine, we take it out of there and they make do. It's not the end of the world. So that was the idea. We're pulling it back. The front of the building is now pulled back so that for the neighboring property, the building's still there, but it's not as far into that view.
But you're basically keeping all the stormwater collection the same as the,
Yeah, all that remains the same. The footprint remains the same. It's all there. Yeah, so there's really, we're reducing it by just a couple of square feet because of those stairs. That's a de minimis change as far as the town is concerned. So it's not anything to really brag about by any means. But yeah, stormwater remains, everything else remains.
yeah, sorry, I just wanted to ask.
Yeah, we gotta, this is an open the public hearing, so it's time for the public to speak.
Yeah, no, absolutely, I will
Does
sit
anyone in the
down.
room have any questions?
In the room?
Hey, Lori.
Hello, good evening, Lori Beard Raymond. I'm here this evening speaking on behalf of the Shelter Island Heights Property Owners Corporation. First, I'd like to clarify that something that Matt said was that this is not a continuation of previous hearings. Those hearings were closed. So this is a new hearing based on the new support, from my understanding. Second, I'd like to read to the record, and I brought a copy for you, a letter that the Heights has written. So I'm reading this letter into the administrative record on behalf of the Shelter Island Heights Property Owners Corp. The Heights understands that the applicant has the right to build an accessory structure on their property. The Heights' continued strong objection is derived from the proposal's encroachment into the adjacent regulated area. Our continued environmental concerns are due to incomplete plans and calculations and the fact that the exterior of the proposed structure is not in keeping with the character of the Heights Historical District. Overarching these concerns is the fact that this application does everything possible to cunningly evade the Shelter Island Town Code. The proposal should be a new application and reviewed by the town board. New design plans by Ian McDonald dated May 18th, 2024, and by Matthew Sherman dated May 20th, 2024, were concealed within this package and labeled a supplemental to the original submission. How can there be a submittal to the original submission referenced in the planning board, which the original drawings were referenced in the planning board resolution 25-2023, that were clearly nullified by the Suffolk County Supreme Court on May 7th, 2024. The town code is very clear that a new application is required when there's any new or additional activity. Chapter 129-4G states, any new or additional activity not covered in the original wetlands permit shall require an amendment to the wetlands permit. The amendment follows the same application process as a new wetlands permit. The town code references any new or additional activity. The provision does not state that the town code may be ignored if the building is made smaller or if the activity is considered diminutive by the applicant, the representatives, or the planning board. In comparing the original plans by Ian McDonald dated December 16th, 2022, and the drawings prepared by Matt Sherman dated August 22, 2023, the supplemental submission being considered at this hearing are dated May 18th, 2024 by McDonald and May 20th by Sherman. The plans are very different. The May 2024 plans include the following new or additional activities that should be required on the June 6, 2024 supplemental submission to a new wetlands application. Number one, The second floor has been reduced in size and layout has indeed changed. Number two, the room labels have been changed in the resubmitted plans. For example, the area originally labeled kitchen and kitchenette are now referred to as a wet bar to camouflage the actual intended use of the room. Number three, the current plans reference a reduction in size of the pool patio. Some of the disturbance in the adjacent regulated area. What impact will the additional disturbance in the adjacent regulated area have on the environment? And should this calculation be added to the 428 square foot porch encroachment in the adjacent regulated area? Driveway locations have shifted and the stormwater water calculations have changed. Neither the original nor the updated plans contain the required copy of the Suffolk County Health Department Services permit for the application for the permit under Town Code Section 129-4C. Number 6, McDonald drawings A03 now include water and sewer laterals, which are different from what were submitted to the Suffolk County Health Department dated September 11th, 2024. McDonald drawing A20 depicts the overall building as being lower than the original plan. In addition, there's a height change on the FEMA first floor elevation. Number 8, McDonald drawings A30 and A31 now depict the covered porch as 1 story. There's also been a change to the exterior door location of the porch, and as Matt mentioned, the stairs. A9, as the second floor has been reconfigured, a window on the west elevation has been eliminated, making the west elevation look more like a solid wall. Number 10, the original McDonald plans differ from the current McDonald plans, and Sherman plans conflict and have inconsistent grading options. We have 3 drawings with different grading options. The current plans bring the grading closer to the immediate adjacent neighbors on the McDonald plan. The height is concerned about flooding to those adjacent properties. The flooding concern is real and collaborated by the town's environmental consultant's advisory memo dated November 4th, 2024. Number 11, the HVAC encasement on the second floor has been changed on the original submission and resubmitted. The original plan showed slats and the current plan shows a large open lattice. What impact will this change have on noise heard by the immediate adjacent neighbors? The height reiterates that with the original request, have the HVAC units moved to the east end of the proposed structure, away from the neighbor. The planning board made extensive violations of town code and town process in this application. The applicant and the planning board have never considered alternatives to the proposed structure in the adjacent regulated area in accordance with section 129(5)(a), 5, and 6. No alternatives have been submitted or shown in any of the public hearings. There is no hardship, and the applicant is not trying to save an existing structure. The applicant refuses to make the structure smaller or consider ports outside of the adjacent regulated area. The original wetlands permit, resolution 25-2023, dated September 12th, 2023, was nullified by the Suffolk County Supreme Court on May 7th, 2024. Number 3, the town building department rescinded its building permit on May 16th, 2024. The significance of that is the McDonald plans are dated May 18th, 2024, 2 days after the building department rescinded its permit from the approval of the plans that they gave. CAC was voted unanimously on the first submission and has never had the opportunity to review the alleged supplemental plans containing the changes above. Number 5, the notice of the original disapproval, which was based on the original plans, is now expired. The town building department has not reviewed the second set of the alleged supplemental plans dated May 18th, 2024, containing the changes, nor has the building department issued a new unexpired notice of disapproval. Number 6, the town board was not listed as an involved agency for SECRA by PW Grosser, despite the only entity that has jurisdiction over wetlands permits, according to local law 5 in 2024. All roads lead to the fact that this submission before you today should be a new application heard by the town board, where nearby neighbors and island residents would have assured of an objective determination that is not tainted by undue influence. No provision was made in local law 5 of 2024 for the planning board to continue with or grandfather in-flight wetlands application after June 12, 2024. In addition, by accepting the so-called supplemental package of information, the applicant has avoided paying additional fees to the town. We urge you to reread the attached letter from Kimberly Shalrea dated June 25th, 2024, and to remand this application to the planning board, the only entity with legal wetlands jurisdiction.
Okay, thank you.
Have copies?
Sure.
How many do you want? Right, Terry?
You submitted in through the record electronically, so they'll have it as well,
We have
Please.
not.
so that everybody can read it. Matter of public record? Sure. Thank you.
Did you want to respond to any of that, or you
Do you
taking
have specific questions? But I'm fine. Thank you, Lori.
notes?
Yeah, we've
Keep going.
keep going,
Public
get
comment.
get everybody else who wants to talk.
All right,
Town said that could be good.
who's next? Hello,
Hello,
state your name, please.
sure, my name is Robert Harper, Harper, and I am a resident of Shelter Island Heights. You might know the house as maybe the George and Millette house, Hoffman's, and you might know it as, I'm blanking, the people we bought it from. But anyway, I do have a home here, it's in the Heights, and this is my first time speaking before any board here on Shelter Island. So I did want to give you a little background on to who I am and why I'm here. And before I got here, my wife said, you have one chance to make a good impression. You don't get a second chance. So she urged me to wear a suit. And I'm currently overdressed anyway, just glad I didn't wear the tuxedo tonight, which was her recommendation. Anyway, so here's who I am, and here's why I think it's important that I'm here. My wife and I own and have been restoring the house at 14 Spring Garden Avenue. It's an 1883 Queen Anne house, and it is one of the most intact houses on the interior. It used to have 8 bedrooms. It's a very large house. You might know it as the house with the green awnings diagonally across from the Cheekwood. I've restored an apartment in the landmark, national landmark, and the New York City landmark, Ansonia, in New York City. We are restoring a house in Mattatuck, also a Queen Anne house, that's on the local South Town Register of Historic Places. I currently serve on the Architectural Review Committee for Shelter Island Heights, and I introduced to Shelter Island something called the New York State Historic Preservation Tax Credits, which apparently nobody here knew about until we came here 5 years ago. I think we've gotten about $100,000 worth of tax credits, not tax deductions, tax credits, which come right off of your federal tax return for people in the Heights. I served 8 years as a commissioner on the Southold Historic Preservation Commission, where we had legal authority over our decisions. I had many applications that dealt with National Register, either individual listings or districts. I also helped form a National Register Historic District. I was one of 3 people who did the East Marion National Historic District, along with Ruth Ann Bramson and Bill Clayton. That took us over 2 years, and I was the one who did the architectural descriptions of all the houses in the district, all the photography, and I wrote the architectural history of East Marion. Let's see, I have 40 years of experience restoring historic houses. I do most of the work myself, I do the research myself, and unless it's something that's way up high, which I don't like, I usually don't hire anyone. So you will be seeing on Spring Garden Avenue, the house becoming more and more what it was based on historic photographs that we have. It's largely intact on the outside too, but there will be a few historic changes. I continue to serve here as a consultant for people who are interested in anything to do with their historic homes. I do not do this as a profession. I have never charged anybody for anything that has to do with historic preservation. And I've made my services available to just about everybody in the North Fork who knows me. All right, so any questions about who I am? What? I'll tell you why I'm here in just a moment. We're good? Okay. So as I said, I've dealt with many National Register listings. We bought our home here 5 years ago because it's in a National Register Historic District. And as I said, East Marion was something that I helped create. There's one thing I wanted to make clear because it appears in a letter that was issued by Teresa Moriarty, who works at SHPO, which is the State Historic Preservation Office in Albany. And it says that this property has been identified as a non-contributing in this district. To clarify what non-contributing means, because my feeling is every house, whether it is historic or not, that's in a historic district, contributes to the character of that district. If I were to tear down my house tomorrow, and by the way, the National Register would not prevent me from doing that, and I put up a glass box, that would be a non-contributing structure, but it does contribute because you see it. And in this case, we have a very, very historic house, an 1883 Queen Anne house that's immediately adjacent to the subject property. I prefer, instead of non-contributing, which has a negative connotation, these houses are not historic. Could be a 3-bedroom ranch. We have a high ranch within the National Register Historic District. It could be something that's outside what we call a period of significance for the National Register. In the case of the Heights here, 1872 is the beginning of the period of significance, which is when the Methodists came here and established a Methodist campground. And I'm not quite sure where it ends, probably somewhere in the 1940s, because I believe the post office had something to do with the end period. So a non-contributing house is something that's not within the period of significance. It doesn't mean that it doesn't contribute to the overall look and feel of the district. Regarding this property, and I have seen the elevations, and part of my job in Southold was to determine the appropriateness of the property being built or an addition to an historic structure. And we would issue a certificate of appropriateness. If this came before me as a member of the Southold Historic Preservation Commission, I would not, in good conscience, be able to give a certificate of appropriateness. And here's some, I could go on for quite a few, but here's some of the reasons that I have. First of all, I don't see any effort that was made to remotely resemble or fit into any other property in the Heights. I have never seen a structure like this in the Heights. Quite frankly, I don't think I've ever seen a structure like this on the North Fork. Many people have said that it resembles a barn from the street, and I believe that the side elevation, I think it's mislabeled on here. It says east. I think it's the west elevation, is a jumble of several different types of window sizes that appear haphazardly on the facade. The south elevation, which is the one that faces the street, has two 2/2 windows that are centered on the gable. And then there's two tiny windows that are just here and here. There's no cohesiveness to that, and that's the side that faces the street. I don't see that there's anything here that addresses the character of the historic district, which started out as a Methodist campground. This is an incredibly beautiful spot. You see it as you go into the yacht club, you see it from the water, you see it from the ferry. And if I were the owner of the house next door, and by the way, I'm not here to represent them, I don't even know who they are, I would be really angry that this is going to be put next to me, a tiny little buffer between them. The west elevation, which is the one that faces the house next door, has just one window on the first floor, and the rest of that is pretty much a blank wall. So they're facing what looks like essentially the side of the barn. There's a letter that was given, I believe, to Mr. Sherman about the impacts on aesthetic resources, which is something that came from SHPO, the State Historic Preservation Office. It says the site is not in, near, or visible from any officially designated federal, state, or local scenic or aesthetic resource. I beg to differ. The house next door is on the National Register of Historic Places and the New York State Register of Historic Places, and it is certainly visible from that. It also says a tall privet hedge screens the property. When I was on the Southold Commission, hedges, trees, any of that made no difference. We had to ignore it because a hedge can be taken out as easily as anything else. The structure, though, will stand there for however long it stands there. Building a structure that diminishes the overall character of the street, it ignores the historic context of the neighborhood, and it contributes nothing positive to its setting, and will be one more erosion of what makes the Heights so special. I'd like to just leave you with a quote that you can ruminate on. This is one that I've always used in my preservation efforts. It comes from, oddly enough, Winston Churchill. And he said, "We shape our buildings, and then our buildings shape us." The reason I live in that community is because it shapes me and who I am. And I know it does for the people surrounding me. I strongly urge you to keep this public hearing open, to allow for more comments on the structure in question. I thank you for your attention.
Thank you. Anybody else want to speak? Michael? No. You just say your name.
My name is Michael Shatkin. Speaking personally, obviously, I'm also sharing conversations that I've had with a large number of my fellow Shelter Islanders. And what distinguishes, well, first of all, we all know that within the nearshore overlay, which this is part of, that it's very special land. It's the edge of Shelter Island and what characterizes it as an island. And as such, there is a law which doesn't apply, which should apply. We are thinly blocked conceptually and legally from utilizing this argument, but I think it bears reference. And that is that what we are here reviewing is something called a supplemental dwelling unit. And you obviously are a board that deals with land use and buildings. What differentiates a supplemental dwelling unit and a residence, and the applicant has struggled with what to call this room, which is well in excess of 100 square feet. It's currently being called, I don't remember its earlier names, it's currently being called the wet bar. But within the larger scale considerations of what we are dealing with, the only thing that keeps this submittal and this design from being a dwelling unit is the fact that there is not a stove occupying a space within the kitchen. And I remind this board and its chairman, who has recused himself, that one of the roles that you routinely participate in is providing white papers and opinions at the request of town board members and supervisors regarding site plan review issues and zoning. And through the years that the chairman has been the chairman here for a period over 14 years, and I know that there are some people who have been on this board for longer periods of time and shorter periods of time, we've all heard the planning real estate agents struggle with this notion of the accessory dwelling unit. You've all heard the stories, it's time to sell my house, therefore I have to roll the stove back out of the kitchen so it can continue to be a supplemental dwelling unit. You've heard about the impossibility of enforcing this law, but this board and its chairman has never chosen to act in an advisory capacity and to indicate how difficult and unenforceable this law is with regard to kitchen versus wet bar. You know, we're now dealing with wet bars that are 100 square feet, 200 square foot wet bars that seat 6, that from a scale of what you're dealing with, it's not a distinction. And the board should address this. And within the nearshore overlay, there shouldn't be this loophole, which has become something that is routinely taken advantage of. Just doesn't pass the red face test. You know, we rely upon our boards to protect not only the interest of property owners, but we rely upon them to protect the interests of neighbors and the community at large and the character of the island. And I see a disconnect here. You know, you're all friends, you're all islanders. It's difficult for me to say this, and I'm saying it harshly, not to be harsh, but to conceptually, you know, indicate how this doesn't make any sense. It looks like a cottage. I'm sorry, it looks like an accessory, not an it looks like an ADU from the outside. You walk around on the inside, you the wheel stove into the empty space in the kitchen. And it certainly is, from all standpoints of zoning and an impact to the community, it's an accessory dwelling unit. It's not this special thing, which is the accessory sleeping quarters, which isn't a thing, it's a loophole. Thank you for your time.
Thank you. Anybody else like to speak? Hello there, just state your name again, I forgot it.
Yes, good evening to the board. My name is John Wagner. I'm an attorney with law firm of Satilman, Ballin, Adler, and Hyman LLC in Upper New York. We are actually litigation counsel in the Article 78 proceeding that was brought that annulled this board's prior determination granting the approval for the application. So I have specialized knowledge of that litigation, which I'd like to propound to you tonight, because I have been watching the subsequent doings after the court initially ruled on the Article 78 proceeding. And I think there's been a lot of mischaracterization of what the court did and what this board is doing right now pursuant to the court's approval. Just to summarize for you, the original Article 78 sought to annul the original approval that this board granted because of the determination by the board to classify the application as a type 2 action under SECR. What that means is anything that's a type 2 action is exempt from SECR. It does not require SECR review. And no SECR review was conducted based upon that determination. The court did in the Article 78 decision that was rendered last year, I'm sorry, back in the spring of this year, was to essentially nullify the approval because it found that the type 2 classification was incorrect. And that in fact SECR review did have to be done because of the town code, which classified applications similar to this as type 1 actions. So it was not properly classified as a type 2 action according to the court. And the court specifically remanded the application to this board to conduct SECR review. Because it's not type 2, that means you have to do SECR. So that's what happened. It did not nullify the application. The court nullified the approval and expressly sent the application back to you to do SECR review and to act upon the application. Now, what has not been mentioned is that the petitioners in that Article 78 went back to the court and said, we don't think you're right. We think that you should actually change your decision and effectively direct that this application should be either declared to be a new application altogether or should be sent to the town board. Because the town board has now passed a law after the court decided the case, by the way, passed a law that transferred wetland jurisdiction to the town board. And the court, same court, in an October 28th decision filed that day, made that day, rejected that argument. It rejected the motion by the petitioners for leave to re-argue and for modification and amendment of the decision, the prior decision. And just to read from that determination, I'm happy to supply a copy to you. You may have it already, but I'll give you a copy as well. The court stated, it appears on the submission of both parties that the governing authority for wetlands permits at the time of the court's issuance of its decision and order was the planning board. Accordingly, as long as the planning board complies with this court's decision and order, there are no new facts or law for this court to consider. Now, what was the court's decision and order? It remanded, specifically remanded the application back to this board and said, do the SECR review, basically, which is what is going on right now. You're in the process of SECR review. You have declared yourselves to be the lead agency for that review. And from what I can tell, no involved agency objected within the 30 days to your preference to become the lead agency. If only an involved agency can object to that preference, and no involved agency said it. I mean, we've heard from the Shelter Island property owners, and they have expressly stated in correspondence to this court that they are an interested party. They're not an involved agency. The town board is not an involved agency because the court has determined that it's you that makes the decision, not the town board. So there was nobody ever to object to the determination of lead agency, and we shouldn't be talking about that now and talking about the town board as somehow being displaced from its proper role to determine this application. The court has ordered that this board will continue the review of this application. It's not a new application. It has been sent back to this board for consideration and determination in accordance with the court's determination, which said that you will do SECR review, which is what you're doing. You will complete that review and you will render a determination. So that's the litigation background. I think needs to be clarified. I hope I've done that. The other thing that I wanted to point out is this idea that somehow this must be a new application. No, it's a pending application. In any pending application, as you're well aware, it's typical as the application proceeds for modifications to be made in design. In this case, yes, there are modified plans, as Mr. Sherman has indicated. If anything, it's not additional, it's not new, it's less. The building has been shrunk in size. You know, the height has been changed because part of the area of the building that used to be over the porch area is not there anymore. Okay, so if anything, the application has been modified to make it less obtrusive. That is not new, it's not additional. So there is absolutely no basis for any argument that some new application must be presented or filed. You have the application, it was sent back to you by the court, you're doing your duties pursuant to the court's order, and I don't think anybody can fault you for that. And I respectfully request that you continue to seek a review and proceed with a determination of this application. Thank you.
Thank you. Anybody else want to speak? Come on up.
Hi, my name is Bill Mastro. I do not want to speak to the substance of what's going on. I want to speak to the optics to a certain degree. And unfortunately, I'm going to have to give you a little background of myself. I am a retired attorney. For close to 40 years, I worked primarily in governance. I was the general counsel to a very large not-for-profit health organization that has many subsidiaries. I also served on a number of not-for-profit boards and was generally the chairman of their governance committees. One of the things involved in all of this is that I oversaw compliance and conflict of interest, internal audit. There are optical issues, and you will make your decision, but I think the better course of action is to not take this on any longer as the planning committee, but let it go back to the town board. Why do I say that? Because in conflict of interest, generally there are three ways to go. The first avenue is disclosure. Disclosure sometimes can just eliminate a problem of conflict of interest because it's basically immaterial. And by the way, we're not in any way implying any malfeasance on anyone by having this discussion. The second is recusal. Recusal happens in a lot of instances, and people will be acting in good faith, but still recusal not to get involved, not to make a decision on something that could have some bearing on them. And then there is a third area, an area of undue influence, an area where it is so dramatic in terms of what the situation is that recusal is not sufficient. Here you have a situation where the chair of your committee is submitting the plans to the committee. That doesn't pass a smell test. Everyone could be acting in good faith. It doesn't pass a smell test because the methodology, the syntax of how you look at things is basically being determined by your chair. And without any actual interaction, there is, by its very nature, an undue influence on all of you because he's the chair. He's the one who kind of knows how you work and do things. So from an optical position, your best avenue is to say, hey, this is going to go to further litigation. You know it's going to go to further litigation. Why put this other piece in here of undue influence? Let it go back to the board, who is now taking, ownership of wetlands. Don't make this more than it has to be. Thank you.
Okay. Anybody else in the room? Stella, no? Anyone out in Zoom?
Kimberly Rhea has her hand up.
All right. Kimberly, Kimberly?
Yes, I'm here. Can you unmute me, please?
You are
Oh, we can
unmuted.
hear you.
We can
All
hear you.
right. I don't see, I also don't see audio here, or sorry, the visual part of that. I don't see it in the screen.
Visual part of
Oh, we
what?
can't hear you.
You need to
You
do it.
cannot hear me?
No, we can't hear you.
Yeah, but you need to do it on your
Okay.
end, video.
But
Mute your own video.
the appearance screen is darkened. It's not showing.
Yeah, you need to do it on your end. We cannot do it for you.
All right, that's good. I just did it. Thank you. Thanks very much. All right. I have some comments, actually. I have some clarifying comments. Legal comments. I must say, I was pretty shocked when I heard Mr. Wagner's interpretation of the Article 78 proceeding and the court's order. I was the lawyer who represented the Heights and the property owners next door who own the property immediately adjacent to the property. I filed the Article 78 petition and briefed it. Mr. Wagner was not even involved in this case at that time. His firm was, but he wasn't. He was involved later with the post-judgment motion, but the remarks that he's made to you about some of the remarks about the effect of the court's order are just patently wrong. They're just absolutely off base. And I'd like to set that forth. The court, after we filed the Article 78 and briefed it, the court actually nullified the entire proceeding. At that point, what had happened was that you all, as the planning board, had issued the wetlands permit based upon the original plans that were done in, I think, 2023. Lori Beard Raymond has recited the dates of these various submissions, but I'm talking about the original plans. Those plans were the basis of the building department's review and the building department's turn down letter, the notice of denial or the letter of denial, upon which you based your opinion. That was the bigger plan. Now after that order was issued, nullifying your decision, nullifying the permit and the whole proceeding. I don't know what Mr. Wagner means by saying that the proceeding wasn't nullified. Of course it was. The whole thing was nullified. And so the court, in accordance with the court's order, which remanded the matter to you after he nullified the proceeding and the permit, he nullified it and remanded it to you for further consideration. After the order was issued, new plans were submitted. The applicant submitted new plans and they were smaller. I mean, there's been much made about this. It's a somewhat smaller project and much has been made about this in this very hearing. So it's not the same project. It's just not. It's different. It's a new project. Mr. Sherman said several times tonight when he was going through his presentation that you had already approved several items of the old plan. Well, yes, you did, but then the judge rescinded that. So it's not approved anymore. Those things are no longer approved, and you can't just compare the two. You have to start this entire secret process all over. And that's what we should be doing here tonight. So I think this suggestion that you're doing what you're supposed to be doing so far, and that is conducting a secret review. But what you're not doing properly is requiring the applicant to file a new wetlands permit application according to the town code. You can't call this a supplemental application because the original one was completely disapproved. It's like it doesn't exist anymore. Moreover, as Lori Beard Raymond pointed out, because it's a different project and the original wetlands permit was based upon the old plans, there are now new items that you're deciding and reviewing. So it must be a new application. You can't just piggyback it onto the old one. The old one was invalidated. You can't just pick up where it left off because the wetlands permit that you granted was based on other plans, it's another project. And as Lori also pointed out, the record's deficient because there has never been a notice of denial from the building department issued on the basis of these new drawings, this new project. So you don't even have that. You're not complying with the code there. The technical record's also deficient. That was outlined in the letter that I submitted that Lori Beard Raymond referred to, and I'm not going to go into that and repeat it here. You have that in the record. But the idea that you're able to just consider this as is wrong. It's absolutely wrong. This is a new project, and it should be submitted as a new application. The second thing I wanted to say was I was pretty disturbed when I heard the acting chairman going through the planning board attorney's bills and read some of the entries into the record for the 3-month period. And I was really taken aback when I heard that in November, which was last month, that she billed you for reviewing seeker correspondence and working on the resolution. Now, you can't have a resolution until you close this record. You have to have all the information before you can even think about a resolution.
That was for the lead agency resolution.
All right, fine, thank you. I appreciate, and I withdraw those comments then. I didn't realize this because actually what was read was the seeker resolution. So another thing, hearkening back to what Mr. Wagner said, we're past the lead agency action here. You're the lead agency. We don't agree with that. We've registered our objections, but that shouldn't be part of these proceedings tonight. That has nothing to do with anything. So I think it's very, very important for you to look closely at this because you really are proceeding upon an application that's not been properly submitted. And you can't just rule upon and review it in its present shape because it needs to be resubmitted. I don't really understand what this insistence upon continuing with this resolution in light of the town code and in light of the fact that after the order nullifying your previous proceedings and the previous permit, newly modified plans were submitted for a different project. And I ask you to consider that. I think it's error and it's not legal. Thank you.
Okay. Anybody else on Zoom? Pam?
Hey, this is Rich Myers. Can you hear me?
All right, well,
Pam's waiting.
Pam had her hand up first.
Go ahead, Pam. Thank you.
Pam, go ahead, Pam.
Yeah, good evening. I'm just going to read this to you. It will just take a moment. My objections here are that the application amendments submitted on June 11th of 2024 require processing as a new wetlands permit. Town code states in 129.4G, any new or additional activity not covered in the original wetlands permit shall require an amendment to the wetlands permit, and the amendment follows the same application process as a new wetlands permit. I think you've heard that enough this evening. It's clearly the situation with this project. You do not have a notice of disapproval from the building department yet on these plans. The original plans were nullified. You can't tack on to that, as I would, certainly support what Ms. Reyes just said. And then the other thing I would like to bring to the attention is also the town board is also an interested agency on this, and I'd like them to weigh in on this opinion about whether or not you should continue to have jurisdiction over wetlands applications or not. As an interested agency, I think they should weigh in. And then the other thing I wanted to add about this project is the siting of the structure is within the Near Shore Peninsula Overlay District, which prohibits construction of buildings with sanitary systems within 100 feet of the wetlands boundary. Now, in the full environmental assessment form, part 1, question 2C on zoning, it's indicated that this property lies within the Nearshore Peninsula Overlay District, and therefore, as lead agency, the planning board must enforce all provisions of the town code, not solely enforce the chapters 129 wetlands code. The CAC denied this application because of chapter 13312F2 provision stating buildings and structures shall not be permitted within said shoreline vegetative buffer, and 13312F3, which says buildings and structures including wastewater disposal systems and sanitary systems shall be located at least 100 feet from the landward edge of a tidal or freshwater wetland. So permitting this new construction, which it's new construction, right? Within this vegetative buffer is 100% contrary to the protections of this overlay district. And this may have a significant environmental impact island-wide, should future applicants request the same waiver of the town code. In Secra 617.4B2, the adoption of changes in allowable uses within any zoning district affecting 25 or more acres of the district, which if you allow this, it sets precedents for the island-wide expansion of this kind of stuff. And the granting of, and in B3, the granting of zoning change at the request of an applicant, which seems like this is what's being requested here in a way, for the action that meets or exceeds one or more of the thresholds given elsewhere in the list also is a type 1 action. So surely allowing the construction of a building that is non-compliant to zoning regulations will set a precedent for future projects seeking to do the same. Now, I am requesting that the planning board prohibit any encroachment into the vegetative buffer and require alternative siting of this building. You see, when you look at where the wetlands boundary is, that 100-foot, part of this building is within the 100 to the 75-foot area. And this has never been approved by anyone on any town board for the past 5 years in a wetlands code permit. I mean, I dare you to find one that has allowed that to happen. And if you allow it to happen in the Nearshore Peninsula Overlay District, you are opening up one big can of worms. And I am suggesting that you request the applicant to remove that extra 427 square feet out of that area before making any other judgments on this. It is absolutely a zoning issue and part of SECRA review. Thank you.
Okay, thank you. Mr. Myers?
Hi, this is Richard Myers. I am the immediate neighbor at 5 Cheekwood Avenue. I am here representing also the neighbors at 3 Cheekwood Avenue, 2 doors down, who are my in-laws, and several other neighbors on what is an uninterrupted stretch of historic homes facing the waterfront from the yacht club through to the North Ferry. I think, and I'm not going to opine on the legal aspects of this. We can let the lawyers continue to debate that in the New York Supreme Court as needed. What I'm here to say is that this whole situation and all of the time and expense to me personally, to my neighbors, to the town, is driven by a complete failure of process and professionalism. It is a failure of being honest, direct, and transparent about a massive conflict of interest, about inside dealing and coziness between architect, engineer, and planning board. And this is very serious stuff. This has island-wide implications. And there's a time to stop loss and stop taking bad advice from people that are conflicted and have led to unnecessary expense and time wasted, thinking that they had power over the town, its elected officials, and its people on matters that are clearly contrary to law, and at a minimum ambiguous and need to be addressed by a higher body. So, as other commenters have pointed out, there is an out here for the planning board to refer the case to an elected body of officials at the town board and at least seek clarity on issues that involve the town code and legislation of the town. And what's at stake here is well beyond a single property or even a single historic district that has its own special characteristics and governance related to it, and has stood up nearly unanimously against this project. But if that's not enough, then this will be a townwide matter that has impacted the voting booths and has impacted the need to clarify town code, which I think has been clearly stated by the voting population. And now the planning board has a choice to keep going down this path, causing more expenses, more argument, more lawyers, or simply refer it back to the town board. Lori and the Heights have listed a number of issues which need to be directly addressed in detail before anyone who has opposed this project, I believe, will have any level of comfort with it. And again, what's at stake here is not just this uninterrupted stretch of historic homes in a very sensitive and historic part of the island. It's not just the views that, because it's a very trafficked, high profile area where countless families and residents walk and drive every single day on their way to and from the public spaces that exist along this stretch, whether it's Willow Path or whether it's the equivalent right of way along Clinton Avenue. All of those things are going to be permanently disrupted by this project. But it's not just about that. It's about the island-wide precedent that is, in my view, well beyond the scope of the planning board to decide. So we remain steadfast in our opposition to this project. Perhaps there was a moment earlier on, if done professionally and transparently, and with clarity around the town code and all of its provisions, that this could have gone a different way. But unfortunately, there's no evidence that any higher body is ready to be serious about this. And so we will take it to whatever level we need to find the seriousness it deserves. Thank you.
Okay, thank you. Is there anybody else out there?
Yes, I'm trying to get online here. Can you hear me now?
Yes.
Okay, I'm the engineer that works for the Shelter Island Heights. I've been practicing engineering for over 40 years. I've listened to the technical arguments and the technical support for the project, which are inadequate. I appreciate your time. I appreciate Matt's time. I appreciate Ian McDonald's time on the project, but I think we've completely missed the boat here. The stormwater drainage issue is one of the most significant ones here, and it's been poo-pooed. Teresa Mason flagged in her report that there should be alternatives considered for stormwater drainage. And the reason is, first of all, it's undersized. It has not been calculated based on the property and the impermeable surfaces that will result after the project is completed. The 2-inch rainfall is completely inadequate, and the rainfall data for Shelter Island shows that it is closer to a 5-inch rainfall. I'm not sure where the 2-inch rainfall comes from, other than it applies to driveways in Shelter Island. So the bottom line is that in a 1-in-a-year storm every year, there will be more than 2-inch rainfall that will be on the property, roof or not, impermeable or not, and it will flood the stormwater dry wells that were proposed, which are also too close to the water table. And there's discussion about the depth of water. The 1-foot depth of water at the site is inadequate for stormwater dry wells. Teresa Mason flagged it. She said that there's a possibility that you should consider alternate stormwater drainage methods, which means that you cannot use dry wells on that property, which means there will be flooding on the property. There's a couple of other issues. The test wells that were done, which determine the depth of water, are inadequate. They do not account for seasonal variations. They do not account for the tidal variations in the depth to water, which means that the stormwater dry wells that are proposed will also be inadequate even at the 2-inch rainfall. So I suggest that the town consider that the rainfall runoff and the method to capture the rainfall to prevent the flooding in the area be considered at more like a 5-inch rainfall, which is what most municipalities are looking for. The most important comment is that the reason requested for the wetlands permit is to avoid a variance to setbacks. And that's in the hierarchy of the town code. It's not the way it works. The way it works, if you look at your code, is that you avoid the wetlands permit by going for the setback requirements or meeting setback requirements, not the other way around. And I think the town should consider that. They have reduced the size of the structure. I understand. That's great. It still does not meet setback requirements to avoid a wetlands permit. And if the only reason to get a wetlands permit is because they can't meet setback requirements, means they should be changing the size of the structure. There are a number of other comments that I flagged regarding construction. The pilings that they want to install, the depth of the pilings, the excavation for the pilings, the dewatering for the pilings, none have been addressed. That's been poo-pooed. It is not just digging a shovel in the ground and putting a piling in to the depth of water. It doesn't work that way. We all know that. I suggest that the plan to install the pilings, whether dewatering is necessary, where it will be, and how much material will have to be excavated to install pile caps to support the structure, should be part of the permit application. It should not be part of an application later on for a building permit, because it affects the wetlands area that you're going to approve a permit for. There's numerous comments. We will provide the written ones tonight. If there's any questions, we're happy to meet with the town to go over it and with Mr. Sherman to discuss it. But at this point, none of that information has been provided. It should be in the application, and Teresa Mason has also flagged it in her report. I appreciate your time, and I look forward to hearing from you in the future.
Okay, thank you. Is there anybody else on Zoom?
I have Nick's comments.
Oh, okay.
Give it to you in writing.
Sure.
This is what he spoke about. He couldn't be here in person, he asked me to
Great.
give you his letter.
Make sure it gets sent in as well.
Yeah,
On camera, okay, yeah. The neighbor.
no, the engineer.
Oh, the engineer, okay.
Thanks, Larry.
You can address some of these things. I can't find, I don't see the flagging that he's talking about. I'm looking at Mason's report right now.
That's something to do offline, right? It's not during this.
Yeah, we can't hold about it, you know.
No, but Matt wants to get up again and speak, which he is,
Yeah,
he's permitted to do that.
Give a couple of very quick responses. Obviously, there's a lot there, so I'm not gonna try and go through everything. I would like to, I'll get a copy of the letter that Lori read into the record earlier this evening from the town so that we can respond to those in detail. One of the things that was mentioned, town code chapter, let's see, I forget which, chapter 13312 F2 and 3, buildings with sanitary systems and wastewater disposal systems. This building goes to the Shelter Island Heights wastewater treatment plant. It doesn't apply. The 2-inch rainfall that Nick had just mentioned, both the ZBA and the planning board and the Heights all accepted a 2-inch rainfall for stormwater control for the property across the street. We would love to have more than that. You just don't have it. So we can't, if we can't make it perfect, we can at least make it as good as we can make it. Let's see, there was a couple of statements about that buildings with living space in them, I believe it was, or something to that effect, have not been approved in the recent past in the adjacent vegetative buffer. So we got,
It's like,
it is, they're all over the place.
Ones are good.
There's a ton of them. There's been, it's about maybe 10 years ago now, maybe a little more than that. On the corner of Winthrop and Cobbitz is the last one that I know of, was a accessory sleeping structure in the nearshore overlay district, in the adjacent regulated area, on property with getting a new single-family dwelling. All of this stuff has been done before. That doesn't mean that this is an automatic approval. That's that whole, the nonsense about, another project creating precedence for this project. Each one of these projects is individual. Each one has to stand on its own merits. So just because those were approved doesn't mean this one should be approved or has to be approved. But what it does mean is the people who are saying that this is something that hasn't occurred before, that's just misinformation. It's just simply wrong. So if you guys have any specific questions for me, I'd be more than happy to answer. You were asking about something from Ms. Mason's report?
Also, the criticism was that the calculations for the excavation for the pilings and the dewatering was insufficient.
Yeah, I'll get that. I think Delandro Andrews did the design for that, so we'll get that from them and we'll provide that information to you, yeah. And one more thing that I should mention, and this is really the whole reason why I wanted to come back up here in the second go-round. Mr. Wagner had mentioned that the original court order annulled the resolution. It did not annul the permit. What the court order said, and I will read directly from it, ordered that the court hereby annuls Town Board Resolution 25-2023. It was a typo, it should have said Planning Board, because obviously you guys are the ones who did it. So they annul the Planning Board Resolution 25-2023 and directs that this matter be remanded back to the board or the town board or such town governing authority as determined by town laws then existing at the time of this decision and order. So the original order clearly in black and white, in no ambiguity, in clear terms, thank you very much, clearly states it's the resolution that was annulled. This isn't a new permit. This isn't an approval that now needs to be amended. It's a continuation of the original permit application. It is not unusual by any stretch of the imagination for an applicant to come back with modified plans as part of the review process. It's what happens. We would like it if everything went through the first time, nice and easy, no problem. It doesn't happen very often. So this is a continuation of the previous plan by the court order. And the court order also says, you guys have to deal with it. You don't have the luxury of punting it to another board. This is your responsibility by the court's order, not by what I want to be true or what anybody else may want to be true. So, thank you very much.
All right. That's it.
Kimberly has her hand up.
Kimberly? You got your hand up?
Yes, I do. Can you hear me?
Yes.
Yeah.
All right, I'd like to just address just what Matt just told the board. Matt said that the court nullified the resolution, and that is correct. It's absolutely right. But the resolution is what approved the wetlands permit. That's what we're talking about here. That formed the basis of the wetlands permit. So, Matt, I'm sorry, you're getting out of your lane on this. This is a legal issue, and you're incorrect on this. The court nullified the resolution approved the permit, and that's why we're back here, but we're back here on a modified permit. You just can't pretend this isn't modified and that it's not a new project. It is. It simply is. So I just wanted to make that clarification. Matt, with all due respect, you know, I think you're a very good engineer, but you're trying to make a legal point and you're wrong about it. Thank you.
Yeah, thank you. Anybody else? Pam?
Yeah, I'd just like to reiterate, 133.12F2 simply says, buildings and structures shall not be permitted within the shoreline vegetative buffer. So for Matt to say that that doesn't apply, yes, it does. And the part about the wastewater and the sanitary systems, you know, just because this will or may eventually hook up to the Shelter Island Heights systems, doesn't mean it's not a problem. If a pipe still breaks in that building, for whatever reason, it's a problem. It's wastewater and sanitary system that could flush out into the wetlands buffer. That's the point of the protection in the zoning chapter. So I have to disagree with him on that 100%. And I do not know if he knows of any new construction of a building like this that's occurred in the last 5 years under a wetlands permit. I'd like to know about it. Thanks.
Okay, is there anybody else out there? Anybody else in the audience? All right, so guess we'll keep it open.
I'm gonna keep it open, yes.
Need to make a motion. I'll make a motion to keep it open, to adjourn this. Do I have a second?
To the January meeting.
To the January meeting. I'll second. Second. Yep. All in favor?
Aye.
Okay. Go wake up again. Rain in his head, he's sleeping on a couch somewhere. Just everyone's leaving. Goes over, everybody's leaving.
We're not special.
It's live.
Have a good nap.
Yes. Okay, so that's the end of the business meeting. On to our work session. The current applications, the Bloom minor subdivision, still waiting on the submission of the final application, and they have till January 14th. So we'll have to notify them of the upcoming deadline. SH 29 West Neck LLC lot line adjustment. I think we're just waiting We've been told that the county has accepted the final plat, and we're just waiting on a confirmation of that, of a actual copy of it. So that application is done. Elliott Bousman lot line adjustment, we extended the deadline to 11 February 2025, but we expect to be over before that with the maps having been signed by me, and they just have to be filed and recorded. R&B, Shelter Island, Radigan lot line adjustment. We're waiting, we have the deeds, we're just waiting on for them to be reviewed, and they have until February 11th, 2025. They'll probably have to ask for an extension. Once the deeds are deemed sufficient, they have to submit them to the county for recording. And upon proof of recording, then maps get submitted for our signature. West Neck Creek Cottages LLC subdivision. They have until April 8th to submit the final application. 3 and 5 Borough Hall Lane LLC lot line adjustment. We're waiting on the recording of the deeds as far as I know, and they have till April 8th to do that. And then to finish up with the new plats to us for signature and then recording. White performance bond, a maintenance bond, those have been turned over to the town board for their review and for them to act on. Ballard Trust major subdivision, we're still waiting on passed the resolution today. That gives them to June 10th,
Table
Oh, the Fowler, I'm sorry, you're right.
Discuss the.
So we're gonna discuss that further. The Fowl and Shearer lot line adjustment, waiting on deeds. And we passed that one today until June 10th. They have till June 10th. Fowler, do you want to wait till we hear from the applicant receiving that letter, or do you want to talk about it now?
We could talk about it now. I mean, I was under the impression we're getting an extra 50 feet of undisturbed, just like, they have in Cobbins Lane.
So it was always my understanding with the parkland that the structure still had to meet, well, correct setbacks, whether it's a front or a side yard. So my understanding on this was that the 50 feet would be from the, would be, in fact, be their front yard setback. And that's for buildings. It didn't mean that they couldn't clear.
Right.
To 100.
Yeah, I misunderstood that. I thought I think it looked better if it were kept natural and,
It seems like asking for 100 feet would be excessive, in all honesty, like trying to like, it is, in theory, in code, there's no requirement. I mean, part of this was to provide a parkland, right? That's the thing. So they could instead not do that at all and just put it all over on one side. And we wouldn't have that big giant stretch. So I think, they're fulfilling it feels like they're fulfilling the request, which is a percentage, and we're asking for a little bit more. Yeah. And we're trying to, I think doing more of like, and you can't touch the ground seems excessive. So I think I'm more on what you're hearing, whether it's the 50 feet of is great, get all parkland, that's part of doing the percentage. And then 50 more feet where you don't have a structure right there. So you'll have quite a bit of space. I mean, it would be nice to stay wood.
But it wouldn't be parkland. I mean, the parkland would stop at the first 50 feet. The next 50 feet would be their land, and it'd be simple, but it just can't be, there's a covenant that can't be.
It could become lawn.
I was gonna ask, it can become.
Lawn, they couldn't have any structures.
Yeah. They thought it was 100 feet of parkland, or 100 feet of vegetation.
No, that's what
they thought.
No,
I think that's what he thought too.
No. They wanted a 10-foot front yard setback.
Yeah, they wanted a smaller setback.
So they wanted to use the 10, and then plus they would accept our 50, so it'd be like.
Well, the 50 is the park.
The 50 is the park.
And then they wanted 10-foot for a front yard setback.
Okay.
So the house could be 60 feet
Okay.
from the road.
So the question I have is, if we go with their compromise, with what they're proposing, how does that look from the view of the roadside? That's where I stand.
Where they compromised too was to actually 60 feet of untouched.
I didn't understand that.
And 10 feet of setback. That's what I understood from what, I mean, that's why we need to wait.
Said
for-
70.
I think you might need to wait for their proposal to be submitted
Yeah.
and
See what
then
they say and.
Yeah.
look at that and then.
And even if we did it 100 feet up undisturbed, they would still have a huge building envelope, very huge.
That's a lot to ask. It's their land.
I think Beth is right. Let's wait to see what they offer.
Yeah.
Yeah, well, no, why don't we wait then?
Yeah.
It's like they could slice it up much
Yeah, 'cause
smaller.
we could come back and offer something and they weren't even asking for it.
Well, I know some of the people who live in those subdivisions where the first 100 feet was sacrificed, and they're very happy with it.
And I know, I know people who were.
There's
so-
one that's not, there's one that cut it down. Yeah, so,
No, I think we should, I personally, I think we should wait and see what they say.
Fair enough, fair enough. Okay. Wetland permit applications. Do I need the room? Did you close the hearing? Do I need? Wetland permit review. Camilla Ferrara,
13 Dickerson.
13 Dickinson.
It might be easier to say.
I think your report that you guys put together is very good. Do you want to describe quickly, either one of you, the project?
So this is 13 Dickerson Drive. It's in the nearshore overlay district. It's actually C-zone. And the applicant is looking to convert an existing roofed entry landing and to make it into an enclosed condition addition that's on the south side of the property. They're also going to have the single-story mudroom addition on the north side. They're a landward addition to existing deck on the south side with an enclosed porch, covering both the new deck and part of an existing deck. And they're going to abandon their existing sanitary system and install a new hydro action innovative alternative septic, partially in the adjacent regulated area. The total construction will result in the number of bedrooms increasing by only one. All construction is proposed within the footprint or within adjacent to the landward side of the pre-existing dwelling, which is already partially in the vegetative buffer. So they're basically just trying to work with the existing structure that has some already in the vegetative buffer. The existing square footage right now is around 1596, and with the deck and patio being 474. The proposed is going to 2,893 for the building, and in addition, the deck and patio is 440. And let's see.
And most of that addition square footage is outside of the.
Is outside of wetlands. Yeah.
Only small.
They're also going to be taking away their driveway. Forgot to mention that, so looks like they'll be doing that. So the.
I'm going to clarify that. They're going to reduce the driveway
Yeah.
out of the adjacent regulated area, so it just remains upland.
Yeah, we're going to expand it on another side, but that's all up in the.
Yeah.
in the-
Then they're also proposing to remove the non-turf buffer in the vegetative buffer and replace it with native grasses. And I guess the concerns that David and I had about the deck being enclosed, it looks like that portion, they might be able to just use their 100-foot exemption.
Yeah, the real question here is, and we looked at what's, looking at maps, looking back to time, it looks like the footprint was the footprint pretty much in pre, so it's all grandfathered in. And so it doesn't look like, I don't see any other construction within the adjacent area or the wetlands. So in theory, they have 100 square feet to work with. They're using less than that.
They're using something minuscule?
Yeah, it's pretty small. It's what was it?
8.
Yeah, it's like 8, yeah. So, but we wanted to make sure that it wasn't, they hadn't already used it. It appears that they have not.
They're also putting the new septic in the adjacent regulated area.
Moving it out of
Yeah, so the old one is much closer than this one will be. It's still in the adjacent regulated, but the importance of having the septic, I think.
Yeah, and we've done that before. We've had people where they abandoned a well in the vegetative buffer and moved it to the adjacent, and we figure that's a better, again, it's better. It's not great, it'd be nice, but there is no space outside of the. So.
You're recommending a slow draw pump?
Slow draw pump, yeah, because of the location.
And,
Did you say, is it on slab?
It's on a house on slab.
Slab.
Where are you gonna put a tank?
The septic?
No, that's a good point.
If you have slow draw, slow draw water, you need
Oh.
a storage tank, and if they don't have a basement.
There's a
There's a
cistern next,
cistern that
next to
we
it.
found, so that the building department noted that they don't have a irrigation permit, and that you can only do that with the cistern anyway, but we noted the cistern, we found it.
In theory, there's two
But
cisterns.
that might be not for potable water.
Yeah,
That's
exactly.
for
Yeah.
landscaping.
Yeah, it's a good question we have to
Marcus
have.
has a good point that probably unless they give up some of their interior space to put a large water tank to accommodate this small, slow flow.
I guess the other.
Well, maybe it's not possible.
The only other question would be is if they're expanding out the house on the other side, what do they building it on?
Oh, yeah,
Put a small,
they could put something.
I'm just saying, it's something we could raise as a question in the,
Well, and I'm saying, instead of saying that they can't do it, let's let them see if they can, maybe.
or if the town board even wants to require it.
yeah, that's right. We're just making recommendations.
But we have asked that in other properties where it's that close.
Yes, we have.
That's so I'm just going on. Benefit.
I think there's potentially ways they could do it. Right.
Okay, so I'm gonna add a comment about the driveway, which wasn't in here. But otherwise, it seems like fairly straightforward and easy.
Yeah, I think it's ready to send on.
The other one is for Gaynor.
No, it's Gayer.
It's Gayer, we keep saying Gaynor, but.
Gayer.
It's actually, it's Gaynor.
At 167 Ram Island Drive. You guys want Marcus or?
Well, basically, they went ahead and rebuilt a deck with no building permit or wetlands permit. The good news is they want to come clean with it now. And the other good news is everything they did within the existing footprint that was prior to Wetlands Code 2001.
Asking forgiveness, not permission.
Yeah. It was flagged by the building department. They issued a stop work order. They examined it. Actually, the woodworking, the carpentry on the deck part, it looks really good. It's all ipe, which is a naturally, rot resistant wood.
And they installed it with gaps for water to go through it, right?
Yeah.
It wasn't tight insulation.
Yeah, and it was 4-inch boards, wasn't 6, but there was framing issues. And I'd like to check with Reed exactly what they are. But I don't believe they're the joists. The joists seem adequate, but I think it's really the footings. Because they just took, like those triangular concrete blocks, they put them right on top. So they didn't go to 3 feet.
Code now requires, not even necessarily the depth, but they require a 14-inch sonotube or a 12 by 12 square foot. So that's probably where the issue is.
Which means potentially if they go and do it, they're going to disturb the ground again.
Yeah, well, they have to jack up and temporarily hold up the deck, and then they can dig a new footing in and then put it back down. It's not a huge.
I'd rather see them do it that way instead of ripping the whole thing up in huge.
Oh, I hope they wouldn't rip it off.
Yeah.
What about buffers on that? Because they seem to, you talk about a rock wall on the beach.
Yep.
And then there's area behind it you thought it was the attempt to put in grass but not completed, but it could be just natural grass.
No, you can see it was
Oh,
landscape, it's clumps together like this. I mean, I think it just should be completed and,
And a lot of that's in the adjacent regulated
It's the
area, it's not
adjacent
even
area.
the vegetated
Right.
buffer because their beach is so steep, so long, wide.
and they have a metal roof, but there is no rain gutters or downspouts. I thought maybe we would suggest having that water collected.
Like that makes sense.
Yeah.
So going back to the buffer, what are you thinking about asking for a buffer?
Well, along the water, along the Gardner's Bay side, I think 20 feet, because it's already there, it's already
Yeah.
not disturbed, they've got the room there.
Isn't
there's
that,
plenty of
isn't that
room
what
for
the
it.
environmental consultant? So
She wanted that, but she wanted along the west side of the property, which I think would be,
Well, I had
But
written
the-
back that maybe that you could do 15 on that.
but you don't have, because if you do that, you're gonna restrict access around the house.
Yeah.
You know what I'm saying? Like, what, if they have to move something, there's a fire.
There's
or
a
something,
there's a walkway,
You
right?
wanna, yeah, there's a walk. Yeah,
And then it just goes right down into that,
Yeah.
that wetland.
So that photo I have of it going down, that's like, then it goes flat, you know? So then you can walk, and then it goes down again, but that's all natural, you know, stuff growing.
So if you're saying 15 is too much to be able to circumvent route, then what are you thinking?
Well, the fact that we're reducing the runoff, we have
Yeah.
I mean, what's already there?
It's fine.
There's natural plants, natural vegetation there already.
So just leave it as.
Just leave it as-
So, yeah, I would say disturbing it might possibly make it worse.
Maybe that's the plan, don't disturb it.
Because it's so tight, it's right there. If you do that, you'd have people falling into the pond, whatever that lake, that wetland
There's
is.
the steps going up to the deck, you gotta go through that area to get to there.
Okay, I will add that one comment and then send this in.
Looks good.
Marks is another wetlands application that Marcus and I went to look at, 7 Larry Lane. It seemed pretty straightforward to us.
I put all my effort into the Gayer one because it was, the meeting for the town board is on the 16th.
Yeah, I know, we have next month to put this together, but
we looked at it.
just,
Notes.
the only access we see to putting in the swimming pool is actually going through the vegetative buffer.
That's the problem, because they want the swimming pool
Upland,
here, which is outside of the vegetative buffer, but to get the trucks there, they gotta go around the waterfront side of the house.
so they need to put in a plan of how, because between the house and the road, it's all landscaped with retaining walls and koi ponds and.
Yeah, it's,
Big crane?
Drop the pool in.
They need roof, dry well collection, they didn't size the dry well for the pool correctly, they didn't size the roof water correctly.
Need some more.
And the denial letter expires on that one too.
on the 13th of December.
So even before they come to a public hearing, they're gonna have to renew their denial.
Is that, they do that with Reed?
That would be up to Reed.
Okay.
Okay, Gardeners Bay Country Club, this would be under special permit site plan review. Gardeners Bay Country Club has come in asking to install a water cistern and a pump house. And the whole assembly will be in the location of an existing pump house. It's going to be a fairly large tank buried in the ground. They are going to put in a new well to service it. And it's from what I've learned, 100 gallon per minute well, but it's variable speed. And then they're going to feed this large, off the top of my head, 16,000 gallon tank. And then that's going to run all their new irrigation equipment. We were tasked to look at it in regards to the comprehensive plan. And Julia, you put some notes together?
Yeah, everyone has that?
Yeah.
Sent it to everybody on the board. So just in considering this application, and again, the points I'm just going to bring out doesn't mean that this application has ignored these aspects, but I'm just saying these are the things you want to think of when you're looking at the Gardeners Bay application. In considering the comprehensive plan and the applicants wish to put in the holding tank and the house to keep all the equipment, is basically the current comprehensive plan as well as the one from 1993, because there are some overlaps between both of them, are the visual aspect of a project, the essence as an open space for healthy recreation and community social building, and any project's effects on water use, in particular overdrawing or contaminating. Again, no implication that this application is doing so, but those are just the things you want to keep in mind. From the 1994 plan, I just pulled up some facts for you. Assure adequate open space and permanently preserve to provide balance in island environment. So you just want to make sure that the project is not being built in such a manner that it's going to change the look of coming down, the road there towards Gardeners Bay. And people are doing leisure activities at Gardeners Bay. Under the open space natural features, they do mention Gardeners Bay Country Club. It's mentioned as a non-historic but a significant place. It's recommended that the town look at zoning ordinance to include aquifer protection of contaminants into groundwater. So again, this is a water project, so just bear those things in mind. Avoid development where impacts on water resources or other natural systems would be destructive. And lastly, avoid over pumping. So, and then I did include some things that we have in the current comprehensive plan, which are still underway. So it hasn't been adopted yet, but again, there is some overlap in terms of Gardeners Bay being mentioned again as a local significant historical resource. Again, they speak of this potential of open space, which is private yet possibly unprotected. Could it be developed? Have some safeguards in place to keep the quality of life of island active lifestyles. And again, under the quality of life, we want to think about protecting natural and visual qualities and protection of critical assets. And again, even though this is a private-owned landscape, it's still open space for people. So those are just some things to think about when you're looking at the project.
The only thing something I did bring up at the pre-submission conference is that I think a variable speed pump is not necessarily appropriate. I think a lower speed pump that pumps at the steady rate 24 hours or 20 hours a day is better than one that's drawing a high amount at 100 gallons maybe, with a float in the tank that if it gets below a certain level, it's going to really ramp up. So I think, like we've been doing for a lot of the houses and suggesting for a lot of the residential projects, something that's at a lower rate, they have this big holding tank, and filling it at a steady flow would be
basically
more beneficial.
Taking water out at a more consistent but lower rate over time versus a bunch all at once. Yeah, makes sense.
Especially this size.
Yeah.
That's the difference.
And if they use that so much water that they're emptying that thing, then that is probably good if it fills up slowly. That means they're using the use of water.
Again, part of it, what they're doing right now is the reason they're doing this is they have a very inefficient watering system. Because they only can draw so much, they only can run a couple heads at a time. And they basically have to go 12 or 16 hours to go through the whole course. So they want to have this big tank so they can water numerous greens and tee boxes at the same time and do it more efficiently when there's times of less evaporation and it's an improved system. So I think this is a very good step. It's just how they worked on the pump that fills it.
How big is the existing?
They don't have a cistern.
There's no cistern at all, okay.
It's just a pump house.
Just a pump, okay. Understood. I was gonna say, I was looking for that. It's like, what's in there now? Oh, so then, and the cistern, it's gonna be all underground, the actual 1600 thing, and it's so basically, okay.
They are also trying to collect some stormwater from the parking lot. Not sure quite how much that's going to be.
No matter what, a golf course uses a lot of water. It's just kind of, that's what they do. And this would potentially have them use less, more efficient. So that's good. It's the right direction.
Less chemicals too.
Yeah.
Okay, so I'll put together a quick memo on that and get it around to you guys to look at.
Yeah, that'd be great. Your comments are good then.
All right, that's all I had on today's meeting. So I'm going to make a motion to adjourn the December 10th planning board meeting, and we're going to enter into an executive session to discuss contract negotiations.
I will second that.
All in favor?
Aye.
Aye.